of the Supreme Court. Should he be successful in the interview, Ngatia will become the second CJ to be appointed from outside the judiciary after Dr. Willie Mutunga. Now, the 64-year-old senior counsel with 2 master's degrees and an aggregate of 41 years of experience in the legal profession was ranked the top lawyer despite resolution by the global chambers in 2019, and is well remembered for arguing the case that resulted in the abolition of the mandatory death sentence. Now, Murimi Mwangi is at the Supreme Court. Murimi Mwangi, what else do we know about Fred Ngatia as he appears before the JSC this morning?
Certainly a lot to expect from Senior Counsel Fred Ngatia as he defends his suitability to be the country's independent Kenya's 15th Chief Justice. Certainly a lot more in terms of the issues that the Judicial Service Commission will be placing against Ngatia, including potential petitions that might have been filed against him. But perhaps most outstanding is for him to explain his connection to the President Uhuru Kenyatta administration owing to his twice representation of the president here at the Supreme Court in election petitions challenging his election in 2013 and 2017, and how that feeds into the whole concept of the independence of the judiciary. That interview expected to begin any time from now, so perhaps we cross over there now.
Good morning, Counsel.
Good morning, Commissioner.
I'm Patrick Shohei, representing Public Service. Karibu.
Asante.
Good morning, Senior Counsel.
Good morning, Maraga.
I am David Majanja, Judge of the High Court, Commissioner representing Kenya Magistrates and Judges Association. You're welcome.
Thank you.
Good morning, Senior Counsel.
Good morning, Commissioner.
I'm Olwande Evelyn, Chief Magistrate. I'm the female representative of KMJ.
Asante.
Good morning, Senior Counsel. My name is Machari Anjero. I represent the Law Society of Kenya.
Good morning, Commissioner.
Good morning, Senior Counsel. My name is Felix Koske. I represent the public.
Asante, Commissioner.
Morning, Senior Counsel. My name is Mohamed Warsame, Judge of Appeal. Welcome.
Asante, my lord.
A very good morning, Senior Counsel Fred Ngatia.
Good morning,
Kariuki. I am the Attorney General, and I'm here by virtue of that office.
Asante, sir.
Senior Counsel, I'm Olive Mugenda, Commissioner representing the public and chairing these interviews. We also have the Secretary to JSC and also the Chief Registrar of Judiciary, Honorable Anna Madi.
Good morning, Senior Counsel.
Good morning, CRJ.
And we also have Frida Mukaya, who is the Registrar of JSC, at the corner there. Thank you. So a few housekeeping issues, Senior Counsel. Please feel free to ask commissioners to repeat a question if you're not sure or to clarify. After 2 hours or so, we will have a short break, and Madam Anna Madi will escort you to where you're going to have your break. Otherwise, it's supposed to be a conversation, Senior Counsel, so should all relax and have the conversation. So I'll kick off the interview by giving you 5 to 10 minutes, Senior Counsel, to tell us why you feel you are the best suited candidate to be CJ. And I will just 5 to 10 minutes, because the other issues will come with the commissioners. Thank you.
Asante, Professor. Perhaps I should first and foremost say I started my legal career at Attorney General's Chambers in 1980. That was the first place I was employed. Within a relatively short period of time, I was allocated very many difficult briefs. I'll mention only 2. I was involved together with the head of station, or head of my section, Mr. Frank Shields, with the acquisition of the land where Kasarani Sports Complex is constructed. The owners of that parcel of land, a company called Salopia Limited, had objected to government acquiring that land because we were using the Land Acquisition Act. And it's a prerequisite in that act that when government is using that act, it's got to be for a public purpose. And because of what was then happening, the owners were saying, this is nothing more than government taking this land for its own purposes. We did overcome that formidable challenge, and after overcoming that challenge in the High Court, then we went on to the issue of compensation. It was handled by the chief valuer, and that is why this republic has a near Olympic stadium at Kasarani. Soon thereafter, Attorney General nominated me to look at a very difficult problem that has persisted in this country, or had persisted in this country from the time of independence. That is the difficulty of an international boundary between Kenya and Sudan. I was entrusted with that task. Ultimately, government, together with the British Council, sponsored me to undertake a Master's in Law program at London School of Economics, and as part of the LLM program, to undertake original research in Kenya-Sudan boundary. I was at LSC. I spent numerous hours at Public Records Office because commissioners, all the documents of this republic during the colony and protectorate status, all those documents are at Public Records Office. I'm sure commissioners, you know where Public Records Office is towards Heathrow Airport at Kew Gardens. So I had to commute from LSC, which is at the Strand, and go to this Public Records Office every other single day, and I acquired a wealth of material. In 1 minute, commissioners, at the turn of towards 1914, the boundary was defined by the British government as a straight line between two fixed points, or in the alternative, such a line that would give to us the customary grazing grounds of the Turkana. Those grazing grounds were never defined, but towards 1938, a survey party established that the boundary was slightly above the straight line. That was not to be. We went on, and Sudan demarcated what they call 1950 Sudanese patrol line. That Sudanese patrol line is what actually triggered my interest in this area. And by application of principles of international law, I actually established that when any government allows a competing government to administer an area, the doctrines of acquiescence, doctrines of renunciation of territory, they all kick in. I hope we'll have an opportunity to discuss this in greater detail, but in one sentence, we were able, or I was able in my research, to establish that the Sudanese patrol line, which is a considerable distance from the straight line, is now the international boundary. So, commissioners, I'm sure you all remember, in 1980s, the Kenya-Sudan boundary was indicated as a straight line. Then in 1985-86, we had an extended boundary that went towards Sudan. The difference in graphic terms is that through this research and the validation that went on in government, we were able to change our international boundary from the straight line to the new boundary, and we acquired 9,680 square kilometers. To put it in context, the former Western province was 7,400 square meters. So we acquired a territory larger than the former Western province. This is one of my research papers. It went through government, it went through validation. I cannot say that it was singular effort. The Attorney General and other organs of state all participated, and ultimately we changed our boundary. I then went to private practice from 1987. I've conducted numerous cases. Of interest would be I acted for ECK in the Kriegler Commission and also in the Waki Commission, where it was demonstrated that weak laws, weak institutions, weak governance structures can actually collapse any republic. Kriegler Commission report demonstrated and illustrated the weaknesses which were within our legal system and the lack of capacity in the electoral process and the lack of independence in the judiciary. I was part of a team. My team leader was John Musyoka Annan. I was his able assistant, and we also had Nyamodi. Paul Nyamodi is one of my colleagues. A team of 3, we represented ECK. It was a gigantic effort. We learned so much about the need to have proper laws and proper capacities in key institutions that deal with elections and the need to have an independent judiciary. Professor, thereafter, I've given my CV. I was instructed to work for National Assembly, and this is interesting, against the Senate in an advisory opinion at the Supreme Court. You may remember that there were the tough wars at the beginning of the 2010 Constitution, which is the superior house. But like lawyers, we do what we know best. We posed what appeared to be a very innocuous question. Which house should originate a money bill? But behind that innocuous question was whose business is it to legislate division of revenue bill? Because if it came to be my client, National Assembly, to legislate division of revenue bill, it means then we're in total control over devolution. And Senate was saying, no, it can't be. It is a joint effort. We came to Supreme Court, we argued on this matter. I lost, but with one dissenting judge saying that the issue was not justiciable. With that loss, devolution became entrenched as a principle that must be followed. But that was not the end of it. Barely 2 years ago, I was again instructed by the Council of Governors also about division of revenue bill. This time because the opinion that had been given to both houses was being ignored. I did that matter, and the Council of Governors was quite happy with the outcome. In between, I have conducted many other cases, and in my view, if I could summarize in 1 minute, you've had a CJ from academia who did wonderful work. I've looked at his transformation agenda. Allow me to say this with tremendous respect to my former lecturer. It is as profound or second in as profound to the Constitution. I can't see any other agenda as profound as Chief Justice Mutunga's agenda. Then you had a judge of this court as a Chief Justice with his agenda, which took us to another level. We have more magistrates, more judges, courts all over the country, a wonderful experience. But what you now lack is somebody who has been a consumer of this service. I've been knocking at the doors of the High Court, Magistrates Court, I've been to all the courts in this republic. I have had that eye that no other would have. For 40 years, I've been in magistrates' court everywhere. I've been as far as Lokitang. I've been in every part of this country. We had 14 High Court judges at 2011. I've been to each of those. I've been to every Court of Appeal station in this country. When Supreme Court started, I was one of the early practitioners in that court. I have practiced in that court. I have wonderful professional relationship with the judges of that court. And I do believe, Professor, that I have that eye, a practitioner's eye, that can be able to see the real weaknesses and the perceived weaknesses and come up with a transformation agenda slightly advanced from access to justice. From access to justice to another agenda that would be, which we will discuss as we get along. Thank you, Prof.
Thank you very much, Senior Counsel. Clearly, Senior Counsel, you are a successful lawyer, Senior Counsel by all standards, given what you have told us and also what you have read from your CV. What I haven't heard, Senior Counsel, that I want you to explain to us is I've not seen much evidence of Mr. Ngatia, the leader. So please demonstrate to the Commission and to the public that you are that transformative leader we are looking for. I'm interested in tangible achievements in leadership and also maybe institutional changes that you have done, and that can be attributed to your leadership excellence, Senior Counsel.
Thank you, Prof. Prof, of course, I must also acknowledge your transformation of an ordinary college to iconic status. So allow me to pick a college, a university college, as an example. I have so many examples, but allow me to take a university college. Commissioners, you may all recall, University of Nairobi, virtually every now and then students will go on strike. It became so perennial that we were wondering whether we should have a university next to the human population around the city of Nairobi because of the rampant wastage that used to happen. About 3 or 4 years ago, I was requested by the Senate to look for what are the issues bedeviling this university. Prior thereto, I had been involved as counsel in a lot of disciplinary cases that went to the High Court. And those disciplinary cases used to have almost a circular effect. You discipline a student, expel him, and then that provokes a riot at the campus. You do not do that, then again another circular effect. And when Senate engaged me with a student population of 80,000, I started working with the university administration. Prof, at University of Nairobi, there are 8 colleges. No, sorry, there are 6 colleges. Each college had its own independent disciplinary process. So you'd have a college, for example, Humanities and Social Sciences at the main campus, with near to 18 faculties under it. You have another college, say, Biological Sciences or Agriculture at Kabete. Each of the 6 colleges would have its own disciplinary structure. Then for the halls of residence, there were 8 distinct. Consequently, Honorable Commissioners, you have, so to speak, semi-autonomous pockets of disciplinary bodies all dealing with the 80,000 students. And of course, what will go to the academic, the colleges, would be anything to do with academic, but for residential, it's what would go to the halls of residence. I studied this, I engaged all the colleges, we had seminars, and we had so many workshops. And then I looked at comparative colleges like Pretoria, Harvard, my former college, JSC, or University of London, and I actually saw what is the problem with this premier university. It's the 7th university in Africa, but they had not got it right. You cannot have a disciplinary process which has no harmony. So what was ailing this college is the fact that there was no harmony in the sentences that are awarded to students. There's no harmony in what is a disciplinary offense. And I crafted a student handbook that was to operate and is to operate across board. So you do not have a student in one college being expelled, whereas for identical offense or misdemeanor or transgression, he is just told, do not repeat that again. Consequently, and I say this without any fear of contradiction, the harmony you now see at this university is a direct attribute of the work that we did. I must, of course, acknowledge that I've received tremendous support from the Senate and from all the college principals and all the academic staff. We were able to actually transform what was becoming more or less a perennial problem of indiscipline to now a college where I'm sure commissioners, you cannot recall the last time you saw university students throwing stones along Koinange Street. And I have many, many other examples of equal kind that I've had occasion to deal with.
So, Senior Counsel, were you the chairman of the board of the council of Nairobi University? Or?
No, whatever work I did as an consultant.
Oh, okay.
I did as a consultant at the request of the Senate. I was reporting to the Senate, and they authorized me to have meetings with any person within the university. So I started off with the academic staff, and then went on with the college heads, and then as we went along, I got across a very, very good idea of why indiscipline had become the order of the day.
So just a follow-up question, Senior Counsel. You're going to be leading a workforce of probably like 5,000 judicial officers and judicial staff. So how will that experience then help you to lead this big workforce in the judiciary?
The principles in leadership, Prof, commissioners, apply for a workforce of 20, and they would apply for a workforce like the Boeing aircraft manufacturer. It is all a question of how you are able to be a leader. I should have indicated that later in life, I did a second master's degree in applied philosophy at Strathmore University. In that, I learned business ethics, philosophy as a tool, and leadership really clearly understood what you are looking for are the 4 cardinal virtues. The 4 cardinal virtues are prudence, temperance, fortitude, and justice. If you have the 4 cardinal virtues, you'll be a leader of 10, a leader of 100, a leader of 1,000,000. It is not administrative skills, it's leadership. And in leadership, you are looking for the 4 cardinal virtues. And this is an applied principle in all the blue chip companies all over the world. We had an empirical research at Strathmore about who are transformative leaders in all the companies in the world. And what stands out is somebody who manifests in deed and in word that you have the 4 cardinal virtues. I can say without any fear that I have tried my very level best to manifest and to inculcate the 4 cardinal virtues in everything I do. Before I conclude, from the 4 cardinal virtues, you collapse into 2 other, so to speak, abilities that you must work on, which is humility and magnanimity. So from the 4 cardinal virtues, on a day-to-day applications, there must be humility and magnanimity.
Okay. Thank you, Senior Counsel. You talked about the vision a little bit when you said that you move from transforming judiciary from access to justice, move it forward a little more. Please talk a little bit about that, your vision, and how you are going to rally all the stakeholders behind you to achieve that vision.
As a consumer of the service, as a consumer of this service, and here I must say that as a consumer I have that little more knowledge because I've been to virtually every court, and we are able to see how that court operates, how another court operates. I've been a victim of delayed judgments, I've been a victim of all manner of things, and with like measure, I have a lot of very good things to say. Before I say anything further, let me acknowledge, Prof, that in our judiciary, we have some of the best legal minds. And I do not say this in flattery, because I have had the occasion in my second master's program to do a research paper on jurisprudence in apex courts all over the world, on very, very toxic or very difficult subjects that happen in our life. This is the end of life litigation. I've looked at America, the Supreme Court of America, Supreme Court of all the countries in the world. We have fantastic judicial minds. What is it that I'll be able to bring which is not there? Access to justice was very well done by the first Chief Justice. Second Chief Justice did as much as he could. But access to justice is both qualitative and quantitative. It's not enough to have courthouses. It's not enough to have many judges and many magistrates and many tribunals and everything. What we now need is another transformative agenda: expeditious disposal of cases. Expeditious disposal of cases is the one that will take Kenya to the next level. It is heartening to hear of cases staying in the court processing, being processed in court for 10 years. We should be looking at a possibility of a case, and we can do this, and I've listened to other Chief Justices. I'm a keen listener of the Chief Justice of South Africa, Mogain, and what he's trying in South Africa is a case management system that can process a case from filing to the determination of that case. Why we must have this is because without it, we will never know statistically how well we are doing. That would be my mission and my agenda.
Okay. Thank you very much, Senior Counsel. One last question from me. In your CV, you have said that you have avoided to be a conspicuous consumption person. But please explain what you meant, because looking at your wealth declaration, Mr. Ngatia, I saw very high-end cars. So isn't that conspicuous consumption, or what did you mean?
No, Prof. Conspicuous consumption has many aspects. I meant social circles. I meant that I am not in social circles. I'm not in lots of the new approaches in life. I do prefer to hold to my own. I prefer the solace of being in a library as contrasted to being in a social circles. And I must say I'm one of those lawyers who are not on the social media, any of the social media platforms. I'll prefer to hold my peace, and therefore I indicated I'm not in those social circles. And I do not mean to say that those who are any less or doing any worse. It's a question of choice.
Thank you very much. I'll now request Commissioner Mwilu, Acting CJ, to ask you further questions.
Thank you. Let us conclude the discussion, Senior Counsel, that you have begun with the Chair on leadership. And that leadership must of necessity lead to the reforms that we have already begun and which must be continued. And since you appear to admire Chief Justice Mutunga, let me start at that point. On the 19th of October 2011, when Chief Justice Mutunga was addressing the judiciary and the nation at large, he said the following words. And I quote him: "We found an institution so frail in its structures, so thin in resources, so low in its confidence, so deficient in integrity, so weak in its public support, that to have expected it to deliver justice was to be wildly optimistic." Now, we want you to please put that into context, Senior Counsel, in terms of the transformation, not what has already been undertaken, but the transformation that Senior Counsel would progress, were God to grant that Senior Counsel becomes the 15th Chief Justice of the Republic of Kenya.
Yes. Chief Justice Mutunga, I think, was being very philosophical with certain words. Being low in public support, I can see that as a direct attribute of the events 2 years or 3 years prior thereto, where the public support to this institution was at its lowest level, culminating to a presidential candidate declining to have his dispute litigated in court. And with that came lots of other events. And one of the issues that I would wish to deal with, and that is why I would wish to gain public support, is that if a case is filed on 1st January, within that year, it should be concluded. Commissioners have also done a little bit of reading, and we have real-life problems in this country. I saw for example, in Costa Rica, an empirical study which has been done. If you get your criminal justice system working quickly, there is an immediate reduction in crime. But here, what we do is the exact opposite. We make our justice system work so slowly. Consequently, there can be a reduction in crime. If we wish to get public support, expeditious disposal of cases becomes a very important thing that we must implement. Deficiency and being thin on resources, I see that happening because it's at that time of Chief Justice Mutunga, I think judiciary had not had its pride of place in the Constitution. We also have the history we are dealing with. When I was joining Attorney General's chambers in 1980, judiciary was a department under the Attorney General. And that is why in the Waruhio Commission, he actually makes a direct recommendation: let judiciary be away from Attorney General's chambers. Therefore, the transformation journey not only is to divest or to have judiciary stand on its own under the Constitution 2010, but to also have its own independent funding structures. And again here, DCJ, I would wish to say all those tools are provided for because there is a judiciary fund. And the Constitution of Kenya only establishes 3 funds: Consolidated, Judiciary Fund, and the Equalization Fund. Consequently, the framers of this Constitution want us to get away from the frail judiciary which was there in 2011 to a very robust judiciary, which is where we want or would aim to have this judiciary get into. I see Chief Justice Mutunga's words as words of hopelessness and frustration in one word, because across them it is the hopelessness of the situation that he's being confronted with.
Senior Counsel, then you would of necessity have to take us out of that hopelessness. Are we still there? That was 2011. Fast forward to 2021. Would you still describe the institution of the judiciary to be in a state of hopelessness?
Far from it. We have made such tremendous progress.
And therefore, then, Senior Counsel, what would be the role of Senior Counsel, were he to be Chief Justice, to move us from here to a place better than what Senior Counsel would have found by the time Senior Counsel was retiring as Chief Justice?
I see myself being in more or less the same position as Singapore was in 1980. Singapore had a huge backlog of cases. I have done a special reading of Singapore and the backlog of cases. And within 4 years, and everything being equal, I'm a Chief Justice of 4 years. Within 4 years, Singapore did overcome that backlog. But not only the backlog, simultaneously they put in place the process or the system I am craving for, that cases are being concluded within a relatively short period of time. Today, Singapore, commissioners, is being cited all over the world. They did this with some assistance from the World Bank, but I do believe, with or without that assistance, they had the mental, they had the determination to do it on their own. It's one of the shining examples of what can be done within a relatively short period of time within a judiciary that really is interested in moving forward. So to answer you directly, DCJ, I'll be the Chief Justice that will end the backlog and simultaneously have the expeditious disposal of cases, not as a theory, but as a practical thing. I would wish to see a criminal case started, and within 6 months, there is a determination. I would not want to be the Chief Justice of criminal cases staying for so long that witnesses disappear and acquittals are because of the delay in the justice system.
Thank you. I think let us pursue that a little. We have the justice chain players. How is my Lord Chief Justice Ngatia going to achieve a criminal determination within 6 months? Will Chief Justice Ngatia force magistrates or judges to go on with hearings where the other justice players are not playing ball? It is advocates who at times will seek adjournments. I'm aware the court is in control or ought to be in control of the case, but there will be genuine reasons for an adjournment. There'll be other maneuvers undertaken by the other justice players, the investigator, the prosecutor, so that the case is not ready and therefore not able to be finalized within this period of 6 months that Senior Counsel Ngatia proposes. What then, what then would Chief Justice Ngatia do to actually achieve a determination of criminal cases within 6 months?
Thank you, DCJ. Like everything else in life, it's not a one-man show. NCAJ becomes the first port of call. The beauty with NCAJ is that all the other players are involved. And it has got to be from NCAJ that a determination has got to be made that we must move this country forward. Judiciary actually comes at the tail end in, for example, the criminal justice system. Coming at the tail end, there is very little you can do. The investigations are done elsewhere. The indictment, the charges are done elsewhere by a constitutional office holder. There's so much prior to alignment in court that becomes almost determinative to how long the process will take. So I will do my very best at NCAJ to say that we must take this country to another level. I would want to get as much cooperation from the other actors, because they are real actors in this system, and without their cooperation, there's nothing that can be done. But the unfortunate thing, Commissioner, says this, that the person who gets the blame from the public is not those other actors, it's the judiciary. And when, for example, and I've done this as an empirical study, when adjournments are also sought by the prosecutors, and they are sought over and over again, a month goes, 6 months goes, a year goes, the person who gets the blame is the judiciary. And those who applied for adjournments do not want to say they caused a delay of 1 year. So it's got to be a collectivity. And the key word here is collectivity of action. And that collectivity will be at NCAJ. But here, at the end of it all, is a question of whether we want to go the Singapore way, which to me is the correct way, or whether we would want to just stay with what we are doing, which to me is the incorrect way. We must have expeditious disposal of cases.
Thank you. If Senior Counsel were to be Chief Justice, you would have, at the very least, 3 very core functions. There are more, but 3 core. But considering the whole 5 or maybe 6, which would Senior Counsel consider to be the most important role, if that is a possibility, of the holder of the office of Chief Justice, and why would that be considered to be the most important role of the office of the Chief Justice?
As I look at the Constitution, my obvious answer would be the first and fundamental role of a Chief Justice is the head of the judiciary. Being the head of the judiciary has its own far-reaching consequences. You therefore become, so to speak, the titular head, not just the titular head, but the real head, the policy head of the entire judiciary. It's by virtue of being that head of the judiciary that you also have the second hat of presiding judge or the president of the Supreme Court. That role of president of the Supreme Court is a role that I have trained myself for. It's a role that can be played or can be assumed by a practitioner of my standing, and the other roles would be the other commissions, this commission being one of them, NCAJ being another one of them, Council of Law Reporting being yet another one of them, and commissioners, I do have that which it takes to be able to have enough time for all those roles.
Which leads me, Senior Counsel, to the next question. And it is the question of balance between the many roles that the Honorable the Chief Justice is required to execute. So how would Chief Justice Ngatia balance between those roles, and what would guide Chief Justice Ngatia in the balancing act between the roles? You have identified that of the head of the judiciary as, to you, the most important one, but that must not make the others suffer. And therefore, what would be the balancing act? Part one. Part two, the Chief Justice, and you've mentioned that, being the President of the Supreme Court, must ensure, in my view, that that court works. Must ensure that as the final court, what comes out of that court is indeed final in nature, so that it really doesn't require explanation and so on and so forth. So balance between the execution of duty of the various roles of the Chief Justice to be able to make yourself an effective Chief Justice?
Thank you, DCJ. As head of judiciary, as I indicated, that's a leadership role. And the beauty with it is that in this judiciary, we have very well established structures, statutory structures, which are very well established. And the chief registrar of the judiciary is the accounting officer. It's not my role to try and micromanage that statutory duty. But I do have an interest to ensure that it's well done. So my first port of call would be the leadership advisory committee, because I would want to carry the entire judiciary or to be with the entire judiciary. I'll regard that as my cabinet. Being my cabinet, I'll be able to know what is going on in the Court of Appeal, in the High Court, and courts of similar jurisdiction. In all probability, we should also have a magistrate with us. The CRJ is with us. Heads of directorates are with us. I would want to have very structured meetings with all of them, because that is the cabinet. And with that cabinet, because I'm still ultimately the one reliable, I should be able to know what is going on at every level of this judiciary, including the Cathy's courts, and including how many tribunals have transited and what we are doing about it, and including the improvements we can make, like small claims courts and how we get them going. So it's not difficult for me, because I have with me a dedicated team that I do hope I'll be able to work with quite effectively.
Thank you, Senior Counsel.
But if I could explain about the Supreme Court, because you had also asked me about the Supreme Court.
Yes, please.
The Supreme Court, being a collegiate court, I'll be one amongst equals. And what I'll do from day one is to personally call all the Supreme Court judges, and we shall have a meeting as equals. Collegiality, commissioners, does not mean, and I must say this, it does not mean that I impose my views on them. it does not mean unanimity in decisions. That's not what collegiality means. And we, as a Chief Justice, I'll try to have very robust engagements by the judges. I'll not stifle them by telling them, look, let's decide this way. Sometimes, most times, by having individual opinions is the growth of law. But if you stifle it by having unanimity, you are not going very far. But of course, in such certain very divisive topics, like say racial segregation, you'd want to have the entire court with you. But with the ordinary cases that go to the Supreme Court, I would want the individual judges to actually show their best. If I could digress a little, we remember Judge of Appeal Nyarangi, because of his individual opinion in motor vessel Aurelian. And we cite this to my Lord every other day about Judge Nyarangi said this, and we all remember him for that. In other words, individual opinions do immortalize judges, particularly if they are well done. I'll be able to balance that work because of my deep desire in development of law. Law is my passion. Instead of other pastimes, I would have time, even in the evening, to read and to generate my opinions. And even in that court, the Supreme Court, I'll try to have the same thing, expeditious disposal of cases.
Thank you very much, Senior Counsel. Let's go to a different area now. You must have come across someone called Montesquieu. You will tell us who that guy is. Tell us what he said, what is he known for, and how does that relate with interdependence?
Very good. That's cause for me to quickly remember my reading in philosophy. Up to around 17th century, I may be mistaken, maybe a little earlier, man was living in what can be described as state of nature. A state of nature meaning there was no community or there was no law and order. That state of nature meant you are on your own. Consequently, life was very short, very brutish, very violent. Because of living in that state of nature, although lawyers want to take advantage of this, it is actually philosophers who actually saw a need of moving from the state of nature and to live within a community. And the first, if you could allow me, DCJ, before we go to Montesquieu, the first philosopher who saw the need to move from the state of nature to a community is John Locke. John Locke, or either John Locke or Hobbes, it's John Locke, who actually said that much as we want to go to a community, there are certain rights we cannot surrender. The first right we cannot surrender is life, liberty, and property. But we can surrender other rights of protecting ourselves. We surrender them to this community or this body politic that we shall create. So those three rights which could not be surrendered are today the rights we talk about, which cannot be alienated. But soon after John Locke came Montesquieu. Montesquieu said, even as you move from the state of nature, there's something you are missing. The first thing you are missing is absence of a body that can make laws. Because yes, we are moving now to a society, a community. We have an absence of a body to make laws. Next thing you are missing is an impartial judge. The third thing you are missing is somebody to enforce the laws. So Montesquieu, a French philosopher, is the one who is credited the world over by having the separation of powers. Separation of powers is not a lawyer-driven exercise or initiative. It came from these philosophers of the 17th century. That separation of powers was quickly taken over, as well as the three rights which cannot be surrendered, and the Thomas Jefferson, as you may recall, in his Declaration of Independence, he ran away with it. And in America, the Declaration of Independence, which was done, I think, in 1770-something, had the three rights: right to life, liberty, but then he twisted, Thomas Jefferson twisted the property, and he said, pursuit of our own happiness. So the Declaration of Independence of America is a direct attribute of those philosophers. I hope I have answered you fully.
Save for we would like you to say something about what Montesquieu said, and which I think you have sufficiently explained, related to interdependence.
Interdependence, the beauty with interdependence, therefore, even at Montesquieu level, you have the three powers, for lack of a better word. One creating the laws, another one the impartial judge, and another, the third one enforcing. And this become the legislature, judiciary, and the executive. Their interdependence is that you, as the executive, you require the laws to be enacted by legislature. And as a judiciary, you become the impartial arbiter of any dispute that will arise, either horizontally or even vertically. And in that, I see, as a matter of fact, that is the same thing that is today known as the separation of powers within our Constitution. The interdependence meaning that you are not isolated. Could I say this? Judiciary is not created for itself. Judiciary is created as a service industry to the people of Kenya. So if it's understood we are service industry for the people of Kenya, we are not created for ourselves, then we become interdependent, because the people we are serving are the people of the Republic of Kenya. Both executive, both legislature, and more important, the 47 million or 40-something million of our citizens. That is our core business.
Thank you, Senior Counsel. I have two final questions. And the first one will be as follows. Would you say that the jurisprudence emerging from the Supreme Court confirms the transformative nature of the Constitution, or it belies it? And while still at the Supreme Court has exclusive original jurisdiction to hear and determine disputes relating to the elections of the office of the President, arising out of Article 140 of the 2010 Constitution. Please, with the reference to Section 83 of the Elections Act, the various amendments thereto since 2016, and any other relevant jurisprudence that comes to your mind, Senior Counsel, please discuss the role of the Supreme Court in the nullification or confirmation of a presidential election. And please tell us whether that jurisdiction should rest in the Supreme Court, and what the challenges of hearing that important case are to the judiciary as a wall.
DCJ, you put me in a small fix, but I'll navigate. I'll definitely navigate these very difficult areas. The first one is easy. Supreme Court has come up with some very transformative judgments. Very, very transformative. Let me say this. The Murwateto case, although misunderstood and misapplied by courts in Kenya, has won the pride of place all over the world. I do not have, but I can provide to the Chief Registrar. I was just going through my searches around Murwateto. It is quoted with approval in Barbados. A whole paragraph of Murwateto is quoted with approval. Not just Murwateto, but a whole paragraph of how the Supreme Court came to arrive at a decision that a mandatory death penalty is an illegality. But having said so, I think I could say a word or two about it. In Murwateto, which I had occasion to argue, the question was not about death penalty as such. The question was about a colonial relic. In 1938, the colonial masters inserted Section 204 in the Penal Code. They did the same in other colonies, Malawi, Zambia, Belize, a few other colonies. But at the turn of independence, those other countries had amended their law. But in Kenya, 40, 50 years later, we still have this Section 204. My attack was on a mandatory death penalty, not the question whether a death penalty is constitutionally viable. It could be viable. But a mandatory death penalty means that we are sharing our judicial power with the National Assembly. Judicial power cannot be shared. The unfortunate thing, Commissioners, is this. I think Supreme Court didn't make it as explicit as it could that this applies only to Section 204. For the simple reason that Supreme Court thought you can bring into place other actors like Attorney General to come with proposals. Hopefully after they have come with proposals, then Supreme Court will give further directions. As fate would have it in this country, there is a word called lethargy, and after a year, the year that Supreme Court thought that the report would be there was no such report. I lost track with the Murwateto case. But I do know as a fact that what Supreme Court would have wanted to do was not done because the other players in that who are defined by name failed to do that which they were supposed to do. But it's not too late. In the event that you honor me with this position, I'll immediately get to Murwateto, see how the judges who could hear it or to come to terms with how we now do not allow it to be a way of people running away from what are otherwise valid sentences.
Murwateto Senior Counsel is one case. Another one that is transformative?
Another case which would have been transformative but didn't become as transformative as I thought was the arbitration appeals. Because we lost the opportunity of Kenya attracting arbitrations from all over the world like other countries have. That case was going towards making arbitration insular from judicial intervention. The Supreme Court almost reached there, but backed out by saying that go back to Supreme Court and let Supreme Court see whether it was. So those are the two that would immediately come to mind. As regards presidential election petitions, could I start off with the challenges? The first challenge every Kenyan would say is the 14 days. It's not a challenge. We have done it 3 times. We have done it because lawyers in this country do believe that you can do tasks within a relatively short period of time. I say this in contradistinction to what happened in Zambia. In Zambia in 2016, they have the same law. The lawyers took 10 days, exchange of papers, another 2 days, case discussions and case conference, and they remembered they have not had their case on the 14th day. So the presidential petition was not heard. It was not heard because they started saying that can there be extension of time? Needless to say, the lawyer for the successful party said it's cast in stone, it's cast in the Constitution. So I do not see that as a major problem. Section 83, DCJ, in 2013, it was applied fully. It's on the basis of Section 83 that the election was upheld substantially. Come 2017, there were difficulties. The court, the majority decision did not apply, as I remember, Section 83. Dissenting judgment, I believe, of Supreme Court Judge Joki dealt with it. But then there was an amendment by National Assembly. Many things were done. The amendments have been struck off, I remember, by one of the petitions by Katiba Institute. So we are in fairly murky waters about the application of Section 83.
Who should start hearing that case, Senior Counsel?
Sorry?
Which court should?
A presidential petition, I would, without reservation, say, should be the sole preserve of the Supreme Court.
Reasons?
We have a lot of similar jurisdiction. Malawi, as you know, has the similar jurisdiction. They nullified the presidential petition, I think, last year. If we do presidential petition in any other court, then there will be issues about appellate processes. I do believe Supreme Court has won its pride of place by having dealt with 3 presidential petitions, and in all 3, the actors may have had reservations, but by and large, is now an established jurisprudence of the Supreme Court.
Now, to my final question. Right now, as we are sitting here, there is the debate whether or not the 15th Chief Justice of the Republic of Kenya ought to come from inside or from outside, the insider-outsider debate. What is your view of a practitioner, in effect an outsider, at this particular time coming to head this very important institution? Justify your answer with some basis. And that will be my last question to you, Senior Counsel.
Thank you, DCJ. Maybe let me start with the last. United States of America, which has the pride or prides itself as being the most liberal democracy, from 1896 to 1953 had racial segregation as part of its judicial policy. Schools were on racial basis. A black boy, black girl will go to a black school. Similarly, a white girl, white boy will go to another school. Public transport was in the same way. Supreme Court in that country was divided for over 70 years. They had several judges, eminent chief justices, they could not see that segregation is an archaic practice. 1953, General Eisenhower nominated Warren as the Chief Justice. Let's look at Warren. Warren was a very successful lawyer, had conducted numerous prosecutions in the United States of America. He was one of the most brilliant lawyers America had seen. He then transitioned to be the governor of California. Was a governor, I think, for 2 or 3 terms. In 1952, this Warren man was so popular he thought he could stand as a president and sought the nomination of the Republican Party. He was defeated by Eisenhower. He subsequently became the Chief Justice of the United States of America. I emphasize this insider-outsider difference, how difficult it then becomes. Warren is coming from a lawyer who became a governor. He's never held a judicial position, didn't have the longevity of private practice like I've had, and he became the Chief Justice. And then the question came in his court about racial segregation. Brown decision. Warren marshaled all his colleagues, and they had a unanimous verdict that there can never be racial segregation in the United States of America. Something that had been unable to be done by chief justices, career judges who had been appointed as chief justices. Same Warren, you remember in the next case, Loving against Virginia, you could not marry across racial barrier. A black boy could not marry a black girl. And Warren came with this very beautiful sentence, that love resides in your heart. And no state has the business entering your heart. Unanimous verdict. He managed to defeat racial segregation in the United States of America by his judgments. Look at the first judgment by Warren. This of racial segregation in public schools and transport, 12 pages of brilliance.
All right, Senior Counsel, we have heard about Warren. Now tell us why are you saying the outsider therefore is better than the insider?
No, I'm not saying there's anybody who is better than the other. My point is this: please look at merit. Please, let's not have this distinction in JSC as my plea to you that there's anybody who is an outsider, there's anybody who is an insider. The hours I have spent in judiciary before Supreme Court came here, this was our High Court, Honorable Commissioners, this was our High Court. I've spent more hours in the library here, I've spent more hours in court here than cumulatively a few judges have spent in their judicial life. In other words, I do not see it as a correct description to call a practitioner an outsider. I prefer you call him a consumer of judicial service. No, definitely not an outsider. I'm as much part of you, I hope I will not be rejected, as much part of you at all times, because I'm a consumer of your service and I represent the people who actually become the beneficiaries of judicial service.
Thank you very much. Thank you, Chair.
Thank you very much, Senior Counsel. Just a small clarification. I took an interest in your answer by the question from DCJ on this Bureaus of Accord. Is it Montesquieu.
Montesquieu.
Yes, and you answered very well. You answered very well, really giving an academic answer. And my question is, Senior Counsel, is this philosopher someone who, in a lawyer, would remember what they said from their judiciary philosophy class, or is it that you read a lot of philosophy?
Professor, I will say this without any fear. I did a bachelor's degree in law, University of Nairobi, a master's degree in law from possibly the second best university in the United Kingdom. We never learned philosophy. I learned philosophy in Strathmore in my second master's. Philosophy, therefore, becomes one of the most important tools that you must have, particularly if you're going to any leadership position. Montesquieu and all other philosophers, Thomas Aquinas and everybody from medieval times. And if I could, with your permission, the first trial was of Socrates. And you know, probability, my Attorney General may recall, the first trial in 399 BC was of Socrates in the city of Athens. And those are the things you learn in philosophy. It broadens your knowledge, it broadens your judicial approach, and lastly, it gives you a very complete world view of the law and the people that you are to serve.
No, that's okay. I just took an interest because of the way you answered it, but now...
Thank you, Prof.
I'll now request Honorable Commissioner Mohammed Warsame, Judge, to continue the technical questions.